All right, so as you heard, I'm Sam Ventola. A lot of you have seen us before. We operate Ventola Law Firm. You've probably heard us, if you've been a member of the group for a long time, you've probably heard us do our contracts presentation and our mediation presentation and our estate planning presentation, and you might have heard some of those more than once. Those are the things that we typically talk to about in the leads group because it's the things that you guys are probably most interested in. What we haven't talked about before is the other aspect of our practice, which is doing First Amendment work. We represent religious organizations, churches, and others who are defending First Amendment rights. And you don't typically talk about that here because you all aren't churches. You probably don't have a lot of First Amendment issues. But because there are a lot of current First Amendment issues, we thought it might be fun just to do a different sort of presentation and talk about the First Amendment. So, as we're going through this, please feel free to ask questions. If you have anything to say, let us know. Go ahead and interrupt, because it's time for you guys to find out anything you're looking to know about the First Amendment. A lot of people talk about the First Amendment, but they don't really know what it says. And so the best thing we should do first thing is just to actually look at what the language of the First Amendment is. Congress shall make no law respecting an establishment of religion. So they call that first clause the Establishment Clause. Or prohibiting the free exercise thereof, they call that the Free Exercise Clause. Bridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for redress of grievances. Now, the first thing you notice about the First Amendment is it talks about Congress shall make no law. And that's really the first important issue you need to talk about when you think about the First Amendment, is that it only restricts government. It doesn't restrict private entities. Until the time of the 14th Amendment in 1868, the First Amendment only applied to the federal government. It did not restrict state and local governments. But after the passage of the 14th Amendment, along with the rest of the Bill of Rights, the First Amendment now applies to state and local governments as well. None of those can violate the rights that are set forth in the Bill of Rights after the passage of the 14th Amendment. But even after the 14th Amendment, it still applies to what we call state action. And that means it has to be action by government. A private entity is not restricted by the First Amendment. And so the first application we see of this is the current controversy we have regarding football players. You've seen that over the last couple of seasons, different football players have been protesting before the NFL games during the national anthem. And some people are saying, well, you know, somebody should do something about that. Somebody should suspend them or fire them or discipline them somehow for doing that. And other people say, no, you can't do that. It's their First Amendment right to protest. Well, it really is not. Because they are on company time, because they are doing their job, they are not entitled to protest at that time. And if the NFL or their team were to say to them, no, you can't do that, that is not a First Amendment violation because, again, it's not state action. Maybe any questions about that? Anything so far? Yeah.
Speaking directly to the NFL protests, so what about when certain parties of our government have made certain comments regarding action that should be taken against these people for their protests?
So I think I know what you're talking about. There is no federal law that prohibits a government actor from essentially exercising their own First Amendment rights and saying, this is what I think this private entity should do. There's a statute that some people have said applies. It says you can't, no government actor should conspire with private entities in order to affect the political party of somebody. Even that wouldn't apply because it's really not about his political party. So the First Amendment wouldn't apply, and as far as I know, there's no other federal statute that prevents a government actor from saying.
I just wasn't sure because using that influence is throwing the weight of the government behind.
And that there's arguably something wrong with that, but it's not a First Amendment issue.
Gotcha.
So the first clause we're going to talk about is called the Establishment Clause. This is the clause that prohibits too much government involvement in religion. A lot of people think about this in terms of the word separation of church and state. You've probably heard that expression before. In fact, though, the phrase separation of church and state does not appear anywhere in the Constitution. The phrase comes from a letter by President Jefferson to well, he wasn't president at the time, but Thomas Jefferson, to a church talking about his view of the relationship between government and churches. The actual word separation of church and state do not apply, do not appear in the Constitution. As a result, a lot of people argue that, you know, the Establishment Clause, the only thing it prevents is creating a state religion, and that's certainly part of what the Founding Fathers wanted to prevent. Because of the issues that occurred in England when they were constantly changing between Catholic and the Church of England and people getting killed in the process, they wanted to prevent a state church. But it's not the only thing the Establishment Clause presents, because it doesn't just say there shall be no establishment of a religion. It says there shall be no establishment of religion. So it frankly prohibits government from establishing religion generally. And the way that's been interpreted generally up to now is that it prevents government from endorsing either religion generally or a certain religion. So there are a lot of cases on this issue, and frankly, they're not really easy to pin down what the test is regarding manger scenes in courthouses or putting up a Ten Commandments monument. This area of the law is always in flux. Frankly, I'm not a specialist in this area of law. I don't represent state governments trying to preserve a religious expression, and I don't represent people complaining about that. So it's not an issue of my specialty, but it's a big issue you'll hear about in First Amendment law, the Establishment Clause. So the next clause, and the one that I'm more involved in, is called the Free Exercise Clause. Congress shall make no law prohibiting the free exercise of religion. What does that mean? So for a long time, it was a fairly strong protection. We talk here about the case of Sherbert versus Werner, where the Supreme Court essentially said the government would be required to show a compelling government interest and that their action was necessary in order to justify a infringement with the freedom of religion. However, First Amendment law, free exercise law, changed drastically upon the decision of Employment Division versus Smith in 1983. So Mr. Smith was a guy who wanted to smoke peyote, and he said that he did that in accordance with his Native American religious rights. He was fired by his employer, again, not a First Amendment violation because it's not state action, but he was also subsequently denied unemployment benefits because of that. So he challenged that action, saying for the government to deny me unemployment benefits for taking this religious action, the violation of my free exercise rights. The Supreme Court vastly redefines, Mr. Smith loses his case, and in the process, the Supreme Court vastly redefines the scope of the First Amendment. What the court says is that the First Amendment is not going to be applied unless the government action in question is specifically targeted at religion. If it's a law, a quote, a law of general application, such as a law against smoking peyote, the First Amendment is not going to provide a defense. Now, the very long decision, there's no majority decision. It's all, you have to read a lot of different concurring decisions to try to figure out what the holding of the court says. What emerges is that there are 3 exceptions to this rule that they pronounced. They say they're still not going to interfere with internal church governance. And for that reason, if you're a minister and you say your church fired you because of your race or something like that, you will not be able to bring that claim, because still under the First Amendment, the courts will not interfere with religious internal church governance. They say that this ruling doesn't apply to laws that involve individualized exceptions. Zoning laws are a good example of that. And it will not apply to hybrid rights. If you're not only doing your religion but something else, and that something else is most usually your speech rights, then the decision of Employment Division versus Smith may not apply. So let's talk about that. Oh, so after the decision in Employment Division versus Smith, there were a couple legislative efforts to try to restore religious freedom, because there were a lot of objections to that decision at the time. And the first of these was called the Religious Freedom Restoration Act, which was passed in 1993. And in that act, the government says, okay, well, we're going to say as a matter of congressional statute, if government violates religious freedom, it can't do that unless it passes a compelling interest test. Well, the first thing that happened is in 1997, the Supreme Court decided that Congress did not have the power to impose that decision on state and local governments. That was the decision of Borne versus Flores. So as a result, the Religious Freedom Restoration Act does not apply to any kind of state or local regulation. And second, we had the Burwell versus Hobby Lobby case. So Hobby Lobby case involved Obamacare regulations, which were federal regulations, which basically required religious organizations and others, including for-profit corporations, to provide contraceptive care in their insurance. The argument was made that the Religious Freedom Restoration Act should not apply because it was a for-profit corporation. However, nothing within the language of either Obamacare or the Religious Freedom Restoration Act created that exception. And so the Supreme Court holds in the Hobby Lobby case that because it was federal regulation, they had the protection of the Religious Freedom Restoration Act and they were not required to provide that contraceptive care. Second thing that was done that does apply to state and local governments is the Religious Land Use and Institutionalized Persons Act. And this applies only in two contexts. One is to prisoners, and the other is to land use regulations. And again, the Supreme Court puts back religious freedom protections in both of those areas. Any questions about any of that so far? So what still applies, what still is a main thing in the Constitution, is the freedom of speech clause. Congress shall make no law abridging the freedom of speech. And this is probably what you hear the most about when you hear cases about the First Amendment. What is this protection of freedom of speech and how far does it reach? So again, the compelling government interest test. Unless the government entity that's trying to restrict you can show what they're doing is necessary to a compelling government interest, there will be protection of freedom of speech. So a lot of people ask, well, what about hate speech? Obviously, hate speech isn't protected by the First Amendment. That is not true. There is no exception to the First Amendment for hate speech. Quote unquote hate speech is still protected by the First Amendment. Now, what the cases do talk about is a distinction between advocacy and incitement. So I could get up and I could say the most racist, hateful things, and I would still be protected by the First Amendment, unless I'm trying to get you to do something right then. So I could say, oh, the president is a terrible guy, and I really wish that somebody would take that guy out because he doesn't deserve to live. All of that would be protected. I don't recommend that you do any of that because you'll probably get a visit, but technically that would be protected by the First Amendment. But if I said, hey, that Trump, he needs to go, and I need you, take him out, go right now, that I'm inciting somebody to do it. So may seem like a strange distinction, but that's the distinction the courts have made between advocacy and incitement. But in either case, hate speech, racist speech, whatever, is still protected by the First Amendment. Anybody have any questions about that whole thing? So what are some of the ways that you as business people are going to run into First Amendment issues? Well, one is defamation. Like say somebody puts a review of you out on Yelp or something like that and says, it's a terrible business, don't do business with them. You feel it's unfair. You want to bring what's called a defamation case against them, a case for libel or slander, saying that they told something that wasn't true about you. The First Amendment applies to those cases in this way. So opinions are always going to be protected by the First Amendment. So if somebody puts out an opinion about you and says, I think that they're terrible, there's nothing you can do about that. They're protected by the First Amendment. However, if they're implying or stating facts about you, I hired these people to do the job, they didn't show up, okay? Or I have to tell you, if you think you can trust these people, I know different from what happened to me, you can't trust them. They're either stating facts or they're implying facts. In those cases, you can sue them for defamation, arguing that those facts aren't true. So again, it's not always an easy distinction to figure out, but expression of opinion is always constitutionally protected by the First Amendment. Expression of fact is not necessarily protected. Somebody have a question? Yes?
So that trustworthiness issue, would that be only considered a factual allegation if you also tagged in that due to my experience with them?
You would have to be saying something that implies knowledge of unstated facts, okay? So it gets kind of complicated, and I can't necessarily resolve any particular issue. But yeah, if like you said, somebody says, stuff I know about these guys that you don't know, you can't trust them, that I would say would be actionable because they are implying knowledge of unstated facts. But if they say, hey, you know, look at these guys, look at what you've seen about them on the press already, they can't be trusted, then it appears that they're basing their opinion on what's publicly available, and therefore it is protected by the First Amendment. Another thing people talk about is panhandlers, and they say, can't we pass some kind of ordinance preventing these people on 16th Street Mall from asking for money? No, you can't. Somebody coming up to you on the street and saying, you have money, I don't, you should give me some money, that is a perfect example of protected First Amendment speech. Now, it doesn't mean that they can block you, it doesn't mean that they can threaten you, it doesn't mean that they can prevent you from going to where you're going, but simply passing an ordinance that's saying people can't panhandle would violate the First Amendment. Yes?
What about people protesting, blocking roads and stuff like that?
So that's a good question. The First Amendment only protects speech. So it doesn't protect an action like blocking a road. And so the government is allowed to pass what we call time, place, and manner restrictions. So the government can say, yeah, you can protest, but you can't protest in the road. Okay, you can protest on the sidewalk, on public property, but not on private property, not on the road, and not blocking somebody's access to their store or something like that. Those are called time, place, and manner restrictions. So you are allowed to protest, but you aren't allowed to protest by blocking the road. Now, as a practical matter, sometimes there are protests that are so large that there are going to be thousands of people, and blocking of the road is inevitable. Those are cases where the people should seek a permit in order to say, hey, you know, we're going to have so many people that it's going to create an interference with traffic, and they'll block the roads. That's usually done in advance. But when people go out and, like, as a spontaneous thing, as a deliberate attempt to sort of disrupt the system, block roads, that is not protected by the First Amendment. Yes?
Are those restrictions put in place on like a case-by-case basis, or are they based on kind of a general common sense of what you are or are not allowed to do, or how does that work?
So it basically has to be application of the pre-existing statutes. So if there's a pre-existing statute that says you can't block the road, which there probably is, then they can apply it to you even though you're protesting. However, they can't make new stuff up. They can't, if you happen to live in a small town where it's never been a problem and there's no law against blocking the road, they can't say, well, we're going to enforce this against you because you're protesting, we don't like you. They can't treat you differently because you're protesting. I was asked about the recent school protests where the children wanted to walk out of school because of the gun issue. And I was asked, you know, what should be done about, what should we do about that? Should we allow that? And I said, first of all, you have got to enforce your existing policy that exists as to somebody who would walk out of class for any other reason. Because if you don't, then whoever wants to walk out of class later for some other protest, no matter how stupid or minor it would appear, you've got to do it because you've established a precedent. On the other hand, don't make it worse for them than if they did it for some other reason. You can't make the punishment that they're going to suffer for walking out because of their protest worse than what would normally be applied. Sometimes we call that content neutral. Government has to be content neutral as to its regulation. It can't regulate speech worse than other things, and it can't regulate some kinds of speech worse than others. If it's going to establish a policy, it has to be consistent. So here are some cases that evolved out of the local area that kind of illustrate some of these cases. I don't know if you remember this, but the Rocky Mountain News used to have a policy where they would pay homeless people to stand out on the traffic islands and sell the Rocky Mountain News. And the cities, Aurora, and I think Denver did as well, cracked down on this and says, no, we don't want these people standing, you know, in the middle of traffic islands selling a newspaper. We're concerned it's going to create a traffic issue. And ultimately, the cities won that battle. The city was allowed to ban that distribution of the paper, even though it was considered First Amendment activity, because it was a reasonable time, place, and manner restriction. You can sell your papers, but don't do it in the middle of the traffic island. Then another case was Brown versus City of Grand Junction. Grand Junction had actually tried to pass an ordinance prohibiting panhandling because people had complained about it. And the federal district court in Colorado said, no, you cannot do that. Panhandling is a protected First Amendment activity. Finally, we have the case that's going on right now, which is Masterpiece Cake Shop versus the Colorado Civil Rights Commission. You've probably all heard of this case. This guy who runs a Masterpiece Cake Shop says that when he makes a cake, he only wants to do that because he's celebrating the marriage that the cake was ordered for, and that he shouldn't be required to bake a cake for marriages that he doesn't agree with. So a gay couple came in, asked for the cake, was turned down, and they successfully, all the way through the Colorado system, the Civil Rights Commission, the Colorado courts, the Colorado Supreme Court, argued that the cake shop should be required to make the cake for them and should be fined for not doing it. And so I have a question for you, as it'll test. So do you think that the guy from Masterpiece Cake Shop has a freedom of religion argument for not making that cake?
Yes.
Yes? Anybody else think yes? Anybody think no? Okay, you're all wrong. Sorry, you're all wrong. You forgot, you didn't pay attention to the beginning of the lesson. In Employment Division versus Smith, the Supreme Court essentially eliminated First Amendment protection for freedom of religion, and that still exists as the state and local regulation. There's no First Amendment protection, there's no Religious Freedom Restoration Act protection, there is essentially no protection for First Amendment as long as the restriction in question is neutral as to religion. And this one says you can't discriminate against gay people, so that's facially neutral. You have a question?
Well, but isn't it, I mean, it's his business, right? I mean, it was his business. It's
Right.
his private business. Isn't there somewhere where he has a right to refuse service?
You cannot refuse service in violation of the state ordinance, which says you can't refuse service based upon sexual orientation. So, no freedom of religion argument.
So it was legal, but it was good in Indiana because they didn't have that in state ordinance.
Well, yeah, it's different states because different states have. However, does that mean the guy has to do it? He's going to lose his case? No, he has a speech argument. So, in this case, his argument is, by making me make the cake, you are compelling me to engage in speech that I disagree with. You are requiring me to celebrate a wedding that I don't agree with. And I have a First Amendment speech right not to do that. And the freedom of speech was not cut back the same way the freedom of religion was by the Supreme Court. Now, that case was argued about 2 months ago. It's currently pending in the Supreme Court. We don't know when the decision is going to come down. People ask me, what do I think is going to happen? I don't know for sure. If you hold a gun to my head and make me guess, my guess is that the cake guy is going to win, that the court is going to say, yeah, to force somebody to make a cake when he considers himself an artist, that is compelling him to speak in a way that he doesn't want to speak, and that violates the First Amendment speech rights. They won't find it on religion, they'll find it on the right of free speech. Now, the way these cases come down is just depends on how the justices vote. And currently in the court, there are 4 fairly reliable conservative votes and 4 fairly reliable liberal votes. And it comes down to what Justice Kennedy, who is the person in the middle, is going to decide. Based upon questions that were asked during oral argument in the case and based upon just general background of Justice Kennedy, I think that he's going to find that the guy is protected by the First Amendment, but I am guessing. I do not know. Yes?
So if the outcome actually comes out where they rule in favor of Masterpiece Cake Shop, can he then turn around and sue the Colorado Civil Rights Commission?
He could, yeah. He could bring a case against them for filing that case against him, and he could say it was a violation of his constitutional rights, what they did to him.
And then, so I'm assuming he was protested, I don't really know that much about it, but then could you turn around and then sue again for defamation if you were protesting based off false pretense?
Well, that wouldn't be defamation. Again, nobody's saying facts about him, that aren't true. So, if somebody says to him, you're a bigot, you're a discriminator, you're an anti-gay, those things are opinions, and people cannot be sued for saying those things about him.
Because I'm assuming with social media and the massive amounts of content and how easily everybody's connected, it's probably not that hard to look through news feeds and stuff and find people that are actually saying those things.
Right, but again, if people are saying stuff out on social media who don't actually know the guy and are actually involved in the case, then they're going to be just expressing opinions. And they can say, you know, they can call him names, they can call him the worst names you can imagine, and they could say that he should have his property taken away, he should be fined or imprisoned. That's all their opinion, and they're entitled to express it. Yes?
Could you talk about what's going on in California with the crisis pregnancy centers?
Oh, so another case that's currently pending on the Supreme Court, and in my opinion, I predict that it'll be decided the same day as Masterpiece Cake Shop, involves a similar issue. So there are things called crisis pregnancy places, which are actually run by anti-abortion people. They're trying to get people who are pregnant to come in and come there instead of going to an abortion clinic. Well, in the state of California, they wanted to clamp down on these things because they didn't like them talking people out of abortions. So they passed a statute that says if you run one of these places, you're required to give everybody who comes in or who contacts you contact information for abortion providers so that, you know, they have both choices. And that case is also currently pending in the Supreme Court. It was argued later than Masterpiece Cake Shop by about 6 weeks. And in that case, the crisis pregnancy centers are saying, again, a similar argument. You're compelling me to speak about abortion and how to get an abortion when I don't agree with it. And so that should be unconstitutional. Another thing coming out of California that isn't law yet, so no cases out of it yet, but California recently passed a law that says that nobody is allowed to sell products or services that involve encouraging people to stay the same gender or not to change gender or to change their gender identification. I think it's a First Amendment violation, again, on the speech grounds, not religion, but on speech grounds to say that, you know, to prohibit people from expressing an opinion about gender realignment. It seems like, to me, something people should be allowed to express an opinion about. But California likes to push the envelope, as they say. Any other questions? Yes?
How do you see these issues changing over the course of the next 5 or 10 years as things continue to evolve in the direction that they're going?
I'll give two answers. I mean, the sort of crude answer is it's going to evolve according to how the court evolves. And if you have conservative presidents, you're going to have conservative Supreme Court justices, and that will probably increase the protection of the First Amendment, whereas liberal justices are more willing to allow what we normally think of as violations of the First Amendment in support of social justice and things like that. And so by that calculation, it's just like who's going to be on the court. But I guess another way to look at it is I think that there's a problem with society trying to create an orthodoxy that only these opinions are acceptable. And we have to prevent hate speech, and we have to prevent anti-gay speech, and we have to require people to follow these rules regarding their speech, because we're never going to agree as to what those things are. And I'm hopeful that we'll get to the point where the government does not involve itself in these issues, that people are allowed to protest and express opinions according to what they believe, and not have the government decide who's right and wrong, who can or can't express those opinions. You may say I'm a dreamer, but I'm not the only one. Anybody else? All right, thank you so much for your questions, you guys. It was great. Thank you so much.